Generally, the Administrative Procedure Act, or APA, allows persons to judicially challenge a federal agency's final action or inaction that has caused them harm. However, the United States Supreme Court has held that the APA bars judicial review of agency decisions not to enforce federal statutes where such action is committed to agency discretion by law. But what if an agency's inaction amounts to a dereliction of its statutory duties? Does the APA allow judicial review? In Adams v. Richardson, the Court of Appeals for the D.C. Circuit considered this question in a case involving Title VI of the Civil Rights Act of 1964. Section 601 of Title VI of the Civil Rights Act of 1964 prohibits organizations that receive federal funding from discriminating on the basis of race, color, or national origin. In addition, Section 602 of the Act authorizes agencies such as the Department of Health, Education, and Welfare, or HUE, which funds public schools, to enforce the Act's prohibition against discrimination by appropriate regulations. In particular, the Act contains two measures by which agencies could enforce it. First, termination of federal funding to those not in compliance, and second, any other means authorized by law so long as the agency permits those not in compliance to come into compliance by voluntary means. In 1969 and 1970, HUE concluded that 10 states were operating a racially segregated system of higher education in violation of Title VI. In addition, HUE requested each state to submit a desegregation plan. 5 of the states ignored the requests and never submitted a desegregation plan, and the other 5 states submitted desegregation plans that were unacceptable. Nevertheless, HUE never commenced an administrative action against the states and continued to give them money for the benefit of institutions of higher education. Subsequently, a group of Black students, citizens, and taxpayers, including Kenneth Adams, sued Elliot Richardson, the Secretary of HUE, in federal district court for declaratory and injunctive relief. Specifically, Adams alleged that HUE had been derelict in its duty to enforce Title VI because it didn't take appropriate action to end segregation in schools receiving federal funds. In response, Richardson argued that enforcement of the Act was a matter of agency discretion and not subject to judicial review. On cross motions for summary judgment, the court found for Adams and granted an injunction. Richardson appealed to the D.C. Circuit Court of Appeals.